Welcome to the first edition of Whistle Where You Work, in which guests Caroline Fredrickson of the ACLU and Peter Swire of the Center for American Progress consider the history, politics, and constitutionality of government snooping on our phone and email communications in the name of fighting terrorism. I'm Mark Cohen, Executive Director of the nonprofit group GAP, the Government Accountability Project, the nation's leading whistleblower advocacy organization, and the producer of this show. First up on the show, the extraordinary story of former Justice Department ethics attorney Jesselyn Radack, whose rosy career path was suddenly upended when she counseled the FBI and her superiors that the U.S. Constitution prohibited them from interrogating the so-called American Taliban, John Walker Lindh, without his lawyer present. Ms. Radack now serves as GAPs Homeland Security Director. Welcome to Whistle Where You Work.
Thank you for having me.
You were raised in D.C. and Maryland, went to Brown University for undergraduate, continued in the Ivies to Yale Law School, then went to the U.S. Justice Department under the prestigious Honors Program. Correct?
That's
and then on December 7th, 2001, about 3 months after 9/11, you had a very unusual inquiry at your desk at the ethics office at the Justice Department. Can you tell us about that?
Sure. I was contacted by the Criminal Division Counterterrorism Section, and they told me that the FBI in Afghanistan had the so-called American Taliban, John Walker Lindh, and they wanted to know about the ethical propriety of interrogating him without his lawyer. I had been told unambiguously that his parents had retained counsel for him.
And what did you tell them?
I told them that under the ethics rules that pertain in every state, that they could not interrogate him without counsel because it would be a pre-indictment, custodial, overt interview, which was not authorized by law.
And did they follow your advice?
No, I gave my advice on a Friday, and they called back on Monday saying that the FBI had interrogated him anyway, and what should they do now?
And what did you tell them then?
At that point, I told them that the interview would have to be sealed and only used for national security or intelligence gathering purposes, not for criminal prosecution.
And did they use it for just the purposes you identified?
No. 3 weeks later, Attorney General Ashcroft held a very dramatic press conference in which he announced the criminal complaint against John Walker Lindh. And a reporter asked about the counsel issue, and he said that the suspect here is entitled to choose his own counsel, and to our knowledge has not chosen one at this time. And then 3 weeks after that had another very dramatic, grandstanding press conference in which he said that John Walker Lindh's rights had been carefully, scrupulously honored.
The day after that second press conference, you got a very unpleasant surprise, didn't you?
Yes. Out of the blue, I received an untimely, unprecedented, backdated performance evaluation that was just blistering and contradicted by my prior record at the Justice Department.
And you must have been pretty disoriented when that happened and confused about why all of a sudden this happened. You had some inkling maybe of what had happened on March 7th.
Right. I was very confused. During the preceding year, I had received a promotion and a merit bonus, so the blistering review was really out of left field for me, and it all didn't add up until March 7th, and that was the day that the lead prosecutor in the Lindh case contacted me, and he said, number one, as you know, there's a discovery order in this case for all correspondence related to Lindh's interrogation, and I have 2 of your emails. I wanted to make sure I had everything.
And did they have everything?
No, I had written more than a dozen emails about the John Walker Lindh interrogation.
And these were missing from your file?
When I went to check the hard copy file, They were gone. They were missing. There were 2 pages left in what had been a very thick file.
And was there anything of great significance about any of the documents that were missing?
The ones that were missing were the ones in which we found that the FBI had committed an ethics violation. The 2 emails that the prosecutor actually did possess were innocuous emails that did not even make sense in terms of their sequence and didn't say anything.
So it looks like somebody tampered with your file. You ended up with this blistering, out of the blue performance review, and your boss actually recommended that you quit your job.
She actually told me, if you don't find another job, this performance review will go in your permanent personnel file, which at that time was a real threat to me because I had planned on being a career public servant.
This again must have been tremendously disorienting for you. Were you able to ever recover those missing emails?
Yes, with the help of technical support. When I found the hard copies of the emails missing, I engaged in a number of ballet steps and was able to recover and resurrect a lot of, I think most of the missing emails, which I documented in a memo and Xeroxed in case they disappeared again and turned over to my boss.
And you also shared them with a Newsweek reporter.
Not until a number of months later, when the suppression hearing for John Walker Lindh was rapidly approaching.
There was a question about whether your emails would be included in, available to the defense.
That's right, and by all public statements that the Justice Department was making, it was clear that the emails had not, in fact, been turned over to the court, because I didn't think the Justice Department would have the temerity to make public statements contradicted by its own court filings.
And so after you went to this Newsweek reporter, it must have been with some relief to you that you had relieved yourself of this sense of there's this constitutional violation going on that I'm privy to that's being covered up by the Justice Department.
That's right. I had not been able to sleep for months before I turned the emails over to the reporter, and after that I slept like a baby, and I thought, you know what, I've set the record straight, and this is over.
Mm-hmm. And then did the government let you be at that point?
Not at all. I really didn't realize that I had unleashed the full force of the entire executive branch. And they went to the law firm that employed me at that time and told them I was a criminal under criminal investigation.
Any idea why the government, your former employer, came down on you so hard?
In hindsight, I realize it was because I was bucking the system and interfering with the first prosecution in the war on terrorism and exposing what was America's torture policy in its embryonic stages. At the time, no, I had no idea. The criminal investigation was only the beginning. The government referred me to the state bars in which I'm licensed as an attorney and put me on the no-fly list and had me under investigation.
Put you on the no-fly list? Put you on the no-fly list for what?
Well, that's a very good question. Obviously, it seems to be a big waste of time and resources to have someone like me on a terrorist watch list. And giving the government any benefit of the doubt, the only reason I can imagine my name would end up on such a list is that unnamed government officials called me a traitor, a turncoat, and a terrorist sympathizer in the New York Times and other mainstream media.
It's hard for me to imagine that when you came originally to the Department of Justice as a star out of Yale Law School, that any of this could have been on the horizon in your mind.
No, not in a million years. I planned on being a career civil servant, and I was a big flag-waving, rah-rah government, pro-government, law and order person.
With the benefit of 20/20 hindsight, Do you regret having come forward with your disclosures?
No. Given everything that's happened, I know that answer will not make a lot of sense to people. People ask me all the time, would you blow the whistle again? And my question to them is, how could you not? Maybe I would have done it differently if I knew the unmerciful way in which this administration would go after whistleblowers, but it was the right thing to do, and I have to live with myself.
A remarkable story whose final chapter is yet to be written. Many thanks to Jesselyn Radack for standing up for the rule of law and standing up to the powers that be at the Justice Department at considerable personal expense. When we return, the constitutionality of government snooping in the war on terrorism. Welcome back to Whistle Where You Work. America's founders had all they could stomach of arbitrary invasions of their homes, effects, and papers, and so they enshrined the Fourth Amendment to ensure that their new republic behaved better than the British Crown. And that's why today police may not listen in on your phone calls or read your emails unless a judge first warrants there's probable cause you're involved in criminal activity. But President Bush maintains that Fourth Amendment protections hamstring efforts to defend the nation against terrorist attacks. A bipartisan congressional coalition agreed or bowed to election year fears of being labeled soft on terrorism. On July 10th, the president signed into law a new FISA law, the Foreign Intelligence Surveillance Act, that he says will help our intelligence agencies ferret out terrorists and protect those phone companies that secretly assisted the government's surveillance efforts. Not everyone agrees that the FISA law is advisable or even constitutional, or that phone companies should be let off the hook. Peter Swire is an Ohio State law professor and senior fellow at the Center for American Progress. He also served as the Clinton administration's chief counselor for privacy in the Office of Management and Budget. Caroline Fredrickson is the legislative director of the ACLU's Washington, D.C. office. The ACLU recently filed a federal suit asking the court to declare key provisions of the new FISA law unconstitutional and to enjoin their implementation. Ms. Fredrickson, Mr. Swire, welcome to Whistle Where You Work. Let's start with you, Mr. Swire. Could you walk us through in a highly telescoped way the origins of FISA and what it says today?
Right. Well, FISA started with Watergate, like a lot of the government reforms that we have in place today. In the 1970s, the national security agencies, the CIA, the Pentagon, were doing wiretaps for national security reasons, and they were doing it outside the scope of the law. And FISA was a statute that said from now on we're going to have Article III judges, real judges involved. We'll do it in a secret court, and that way we're going to have the rule of law come in when it comes to these national security wiretaps.
In 2005, the New York Times reported that the National Security Agency was wiretapping phone calls and email communications, and doing so without a warrant. And President Bush admitted as much. And then subsequent to that, several whistleblowers from within the industry came forward and noted that the telecom companies were basically opening up their pipelines to the government to listen in on communications and read communications that passed through these wires without a warrant. 40 lawsuits were filed against these telecommunications companies for invading their privacy. This new FISA law provides immunity to these telecommunications companies retroactively for what they did. Can you speak to the constitutionality of that?
Well, the first step was that it was $1,000 per person if you had your records looked at when they weren't supposed to. And I was actually the first person to put up on the internet the legal analysis for that. And we knew from a USA Today story that was 40 million people at least. So that was $40 billion that Verizon, AT&T, the other phone companies were facing. So that became a huge deal. The constitutionality of removing their liability is what the ACLU suit is going to be testing. And so I think Caroline's really the expert on that.
Well, actually, I think we need to divide. The ACLU is involved in, as you might expect, many lawsuits. In this case, we're challenging the constitutionality of the FISA portion of the FISA Amendments Act that was just signed into law by the President. We also have one of those 40 cases that you mentioned, which is a class action lawsuit. It's consolidated with the other cases in the Northern District of California. In that case, we will test, I am sure, the constitutionality of the immunity provisions as one of the ways of keeping those cases alive. And I think there is a good question. I mean, there are people who've suggested it could be a taking, any number of other things. But I would just say to Peter's estimate of the possible liability of the phone companies, I think that's very speculative, and I think it's also important for people to understand that there were definitely discussions on the table that could have put caps on damages, could have approached this in any number of different ways, but essentially the Bush administration wanted absolute immunity because I think there's more at stake than just the financial cost to these telecom companies. One, there's an important incentive that comes with penalties for companies to abide by the law. And when they've broken the law, even if they have done so at the President's request, there still should be some accountability. And now they're basically getting off scot-free.
The President argues that he's the commander-in-chief. We're in a state of permanent war, virtually. And by virtue of being commander-in-chief, he has the authority under the Constitution, under Article 2 of the Constitution, to wiretap without warrant in order to protect the American public.
Well, and indeed he says that, and I think that is a very frightening analysis of what the President's powers are under Article 2. I mean, it really negates the role of Congress practically altogether when there is any so-called war going on. And I think, as you mentioned, this is a war that could last forever, which means that the President's powers are really unconfined. And simply listening to our phone calls or reading our emails, that's only one aspect of that. There is also the issue of, can he order searches of people's homes? Can any number of other types of incursions into our privacy happen under that very, very radical theory of presidential power? And although this administration has advocated it, I think there has been a resounding no. And even though Congress did ultimately give the President much greater powers in the new law that was just signed than existed under FISA, there was still some understanding that it was Congress's doing so that made it happen, not the President's taking it.
And one part of that is that the new statute has a clear affirmation that the statute is the exclusive way to do the wiretaps, and that they're going against Congress's will if they try to come up with some other program beyond that. So that's an attempt to be a limit on the President's power.
And this new FISA bill is something that you are challenging the constitutionality of Section 702. And you are arguing that although the law itself says that Americans living in the U.S. or abroad, or people living in the U.S. may not be targeted by this law, that in fact this law enables warrantless surveillance of Americans.
Well, absolutely. I mean, I think even the administration would agree that it is a very, very broad surveillance of international communications. And the argument that people who defend the law try and use is that it does require that the target be overseas. Otherwise, you have to have a warrant if an American is the target. But that is the real question, is what does it mean to be a target? And I think there was some much more protective language that was in the bill that the House passed in the winter, which would have said that it was a requirement if a person in the United States, a U.S. person, either a citizen, a legal resident, became a person of interest. That is, our government decided that their communications were just somewhat more intriguing than the rest of our communications. In those cases, they would have had to go back to the court and actually get a warrant. We thought that was not, what the ACLU's, preferred language would have been, but it was far better than what we have now with the FISA Amendments Act.
So talk a little bit about when you spin out your worst case fantasies about what this implies, what kind of scenarios could we be looking at going forward?
Well, I mean, I think, there are lots of different hypotheticals here, but I think one of the things that that we didn't really talk about initially with the history of FISA is that there were not necessarily what the CIA was doing, but what the FBI was doing in a variety of different programs was engaging in surveillance of political opponents. And by really removing most of the oversight from these very great powers to engage in surveillance through reading emails or listening to phone calls, reading text messages and the rest, there is always the potential that these powers could be abused. And I think we have a history to show that power often does get abused. That's the point of checks and balances. I think that's the most dismaying part of this law, is that the role of the FISA court, and people have criticized the FISA court in the past as being little more than a rubber stamp, but at least it was there as a check on the
Something
government's
like
surveillance.
Only 9 out of 12,000 applications for warrants were ever turned in.
40,000, I think, applications that
all
were
the more
granted.
the point. So
I mean, it's over the course of 30 years.
So
but
was it not a rubber stamp?
Well, it's in retrospect, it looks much better than it used to. But I think there was, a much more cooperative relationship between the FISA court and the people in the Department of Justice who were looking for the warrants. And there was a lot more back and forth in terms of, when I think the court said no frequently, but then people came back with more evidence and were able to get a warrant. But I think the point really is that oversight is critical. These powers, and I have no reason to suspect President Bush has misused these powers and has been spying on Democrats or anybody else that he doesn't agree with. But on the other hand,
there's a history here.
There's a history, and I think it's very important for us to maintain that kind of oversight, whether it's a judicial check and balance or much more rigorous congressional oversight than is present in the bill that was just signed into law.
When it came before Congress, Senator Obama famously said that he was going to vote against any bill that included telecom immunity in it, and in fact voted against a particular amendment that offered telecom immunity, but he lost on that vote, and telecom immunity was folded into the final bill, and he voted for the final bill. Did he, and I should say, in fairness, that Senator McCain didn't show up for the vote at all, although he indicated
and would have
that
supported the most extreme surveillance version of the whole thing. Yeah.
So many of Obama's supporters were angered by this. Some 23,000 even registered their anger on his own website or a website supporting Obama. Was their concern well placed?
I'd like. So one thing is quite remarkable if you have thousands of people mobilizing on FISA. I wrote a law review article in 2004, and most people had never heard of the statute as recently as that. So it's in some ways waking up to over surveillance is a good thing, and it's a sign of freedom in America that we can push back when problems come up. The second thing is that Senator Obama had a very detailed response and actually got on the blogs, his leading staff did, to talk about this. There were a number of changes from February when he said he'd filibuster to now. The exclusive authority, the role of the Inspector General. There were various changes in the law that made it more protective of civil liberties. And this law would expire, the one that's just been passed will sunset, so the Congress and maybe a new president would have a different package. So there were changes, and then in legislation you have to decide, is this the best deal we can get today, or is it going to get even worse if we don't take this deal? And I think in that context, he supported the bill.
Well, I generally agree with Peter on most everything, but in this point, I think we disagree. And one of the things we disagree about is whether there needed to be legislation passed. FISA was still the law of the land, even though the Protect America Act that was passed last August expired in February. FISA was still part of our statute book. And so we were protected. The government had a mechanism for engaging in surveillance lawfully. There could have been ways of updating FISA that people generally agreed on, that were non-controversial. This was a step too far. And I also think that the civil liberties protections are very much overstated. It's very limited. Inspector General reports to two committees. that will not be available generally for other members of Congress. It's a fairly limited group of people and a fairly limited number of reports. And I think we also know from I think Glenn Fine has done an amazing job as the Inspector General at the Department of Justice. But his reports on national security letters have not produced a change in the Patriot Act in those provisions. They have been helpful and they have helped educate Congress, and we will continue to advocate on it. But up till now, it's not as though that was a trigger mechanism. So I think we were disappointed. The hope that I have about where, if Senator Obama is elected, is where we can go, is something that Senator Reid, the majority leader in the Senate, has mentioned. He voted against the FISA bill, primarily because of the immunity provisions, but he has said that we need to come back to this. There are a couple of Patriot Act provisions that expire in 2009. There's no reason we can't also address the FISA Amendments Act and try and put back more robust civil liberties protections and try and address the immunity provisions, because there is still a great likelihood that those cases will not have been dismissed by the time Congress comes back in January.
And that kind of anticipated my final question, which is what, in fact, the new administration, whomever is the president, should do with whatever Congress is elected. Senator McCain has indicated that he wouldn't, for instance, persist in signing statements giving the president open and unregulated authority to conduct these kinds of wiretaps necessarily. Senator Obama has indicated some distress over this. What should they do?
So having the Article 3 judges, the FISA judges, have clear authority every step of the way is definitely part of the right answer. And it's unclear in the new law what standard of review applies for them. Clarifying that they really get to be involved as judges should, I think, would be a big part of the answer.
Okay. Everyone agrees that the government must be able to conduct surveillance to prevent future 9/11s from recurring. That's a given. But as America's founders well know, unchecked government power is an invitation for the abuse of that power. The FISA law further opens the door to massive, unchecked government snooping abroad and here at home. The tragic irony is it's all being done in the name of protecting our liberties. I'm Mark Cohen.